Hello, everyone. Welcome this Friday lunchtime webinar. And we're going to be going over policy updates today. For those of you who don't know me, my name is Jamie Bossuat. I'm a shareholder at the Kroloff law firm in Stockton, and my practice focuses heavily on employment law. I help my clients with a range of things, from preparing policies and employee handbooks and conducting trainings to litigating cases all the way through jury trial and on appeal in some cases as well. So my practice kind of runs the gamut, but I do focus very heavily on employment law issues. So what we're going to be going through today is some updates for this year. If you would like a copy of the slides, please send me an email. My email will be on the last slide of the day. Also, you could respond to the email where you got the invite for this webinar, and I'll be happy to send you the slides. Please don't put it in the chat or the Q&A because that disappears at the end of the webinar. And then I do have the Q&A and the chat open for questions as we go along today. Okay, so just my standard disclaimer, this format via webinar does not allow me to provide specific legal advice to you. And this is general educational information and not specific to any particular situation. So today we're going to cover some changes to employee handbooks for 2020 and some other policy type issues. Some wage and hour issues, harassment and discrimination, leaves of absence, independent contractors, and workplace safety and COVID. So that's a lot of topics. I'm going to do my best to move through them quickly. But rather than focusing today on the specific laws or the specific cases that have given rise to the changes, what we're going to do is something a little bit different today. Instead, we're going to focus on what you as employers our human resources representatives can do to ensure that your business is in compliance and to reduce your liability going forward into 2022 based on the changes and trends that we saw in 2021. So we'll go ahead and just jump right in with employee handbooks and policies. So here's the updates for employee handbooks that we may need to make this year, depending on your handbook. The list of relatives that Cfra leave can be used for both public and private employers has now been updated to include parent-in-law. Some of your handbooks may already include parent-in-law. It was part of the proposed list last year and got dropped at the very end. So you might already have that, but if you don't, parent-in-law is now one of the categories. So that would need to be updated. Also, we had some case law that clarified that sick leave is to be paid at the regular rate of pay, as well as meal and rest breaks. We're going to go into both of the topics in more detail later, but you might have policies that you're distributing to employees that address those. If so, they would need to be updated. Warehouse distribution centers now have to provide written notice of quotas to their employees. Garment workers can no longer be paid by piece rate. The disability subminimum wage has been phased out. And happily enough, notices and postings can now be provided to email to your employees who aren't on site. You still have to post them on site, but all of those labor code required notices, etc., those can now be provided by email according to statute. And we're going to go through some of these topics in more detail, but I just have a list at the outset of some of the items that most commonly would require updating for some of our employers. I just wanted to also mention prior updates. For those of you who didn't update your handbook in the last year or two, there have been some changes that would warrant updating if you were doing a new update. One, sexual harassment training changed and expanded. Two, lactation accommodations changed slightly with more stringent requirements. There was a natural hair policy passed or law passed that updates some employer policies and that we recommend including in handbooks. And then last year was a big change to California Family Rights Act because it started to apply to employers with 5 or more employees when previously it was 50 or more. So we do a lot of employee handbooks each year. If you had us update your handbook before, we can do a quick revision if it was last year's update, and get you on your way with that. If you haven't had an update in a while, I always recommend that you take a look or have a legal review to see what might require updating. So if you would like that, go ahead and reach out to me, or of course any other legal counsel that you're using, but we do recommend updating your employee handbooks. There have been changes this year to employee records retention requirements. So the law before required personnel records to be maintained for 2 years. Most lawyers and human resources professionals were recommending retaining those for longer so that they could be used in any case or litigation. The statute has actually now been changed to require them to be retained for 4 years, which then could give rise to additional penalties, for example, if that's not done. Also, the law was expanded so that if litigation has been filed, those records need to be retained until the end of the statute of limitations or the conclusion of the litigation. And so this is, again, something that we always recommend, but we now have to comply with it for the purposes of this law, which gives rise to additional potential penalties. I have a question about whether we do a handbook review versus an update. Yeah, we do both. If you want to reach out to me by email, I can follow up with you, but we can just point out issues we see in your handbook rather than making the changes, or we can give you a whole new handbook, or we can make those revisions for you in a red line. We do the gamut, but we do a policy review as well, if that's something you're looking for. Okay, this is, I stuck it under policies because I know some of you have accommodation policies that you use for your employees. And it's become very popular, and maybe popular is not the right word, but much more common in the last few years for employees to request accommodation for emotional support animals. And there has been some abuse of that process. And so the law was changed this year to place more requirements on healthcare providers who are writing notes for employees to support the request for an emotional support animal. Now they have to have a valid license, they have to have a client-provider relationship, they have to have completed a clinical evaluation of the individual relating to the need for the animal, and then they have to provide some notice to the employee that fraudulently representing themselves as the owner of a service dog is a misdemeanor. So there's a difference between emotional support animals and service dogs. Service dogs have significantly more access rights and their own set of laws that provide them access to public places and places of employment. That would be, for example, a service dog that is providing assistance to someone in a wheelchair, guide dogs for the blind, and there's other types of service dogs as well. They're trained to perform a specific task. They have greater access rights. Emotional support animals fall under the disability accommodation laws. And so it's a different analysis. But we did see this update to the requirements for providers, so I thought I'd include it in here if you're receiving these kind of requests. We didn't have time during today's presentation to go through the gamut of emotional support versus service animals, but it is an update that took place this year that I think is applicable. There were changes, sorry, to settlement agreements that were kind of widespread. We saw this trend start last year with a change in the law that prevented some confidentiality and non-disclosure provisions in settlement agreements that related to disclosure of sex harassment and sex discrimination or retaliation arising therefrom. That has been expanded. So as of January 1st, 2022, now we have prohibitions in the law against non-disclosure provisions for any type of harassment or discrimination based on race, age, sex, all of the different protected categories. So this is much more expansive now. It is still possible to shield the identity of the claimant if that's something that the claimant wants, but you cannot prevent someone from talking about the underlying facts regarding harassment or discrimination. You can still, however, include complete confidentiality in settlement of claims. One second. I have my Q&A box in front of my screen. You can provide complete confidentiality in settlements of threatened claims that haven't yet been filed before an administrative agency or court. There's a change in the status of this law as to once a claim has actually been filed. We also see these similar changes being implemented in non-disclosure agreements for your current employees or for departing employees. So employers cannot condition continued employment or a raise or a bonus on a non-disparagement agreement that denies the employee the right to disclose information about unlawful acts in the workplace. That used to include sexual harassment or sex discrimination, but now that has also been expanded, similar to the settlement agreement language, as of January 1st for unlawful acts outside of sex harassment and discrimination. There are some requirements as to what separation agreements should include. There must be a statement that nothing in this agreement prevents you from discussing or disclosing information about unlawful acts in the workplace, such as harassment or discrimination, or any other conduct that you have reason to believe is unlawful. There must be a notice to the employee that they have a right to consult an attorney regarding the agreement, and that they have a reasonable time period defined as at least 5 business days to do so. And there is an exception, again, for negotiated settlement agreements to resolve an underlying claim that has been brought. So we're going to be updating our settlement agreement and severance agreement templates. If you have your own templates, I recommend a legal review of those before you start using them in 2022. And if you are working with a law firm or a consultant, just be aware that this has changed and make sure you're using a current template that incorporates these requirements now. So that's it on the policy review side. So some of those topics we're going to go over in more detail in further sections, but that's kind of my snapshot of handbook and policy changes that I think are most applicable going into the new year. So if there's no other questions on those, we're going to go ahead and talk about wage and hour. As many of you know, this is really the area that we see the most activity, the most litigation, the most claims, and a significant amount of disability. We used to, 10 years ago, do a lot more harassment cases, a lot more discrimination cases. And now we really see a lot more wage and hour cases. So I want to talk about that trend a little bit more and then go into some of the specific areas that I think you can take proactive steps to reduce your company's liability. If it would go forward. There we go. Okay, so just starting off with the basics. Minimum wage. It's been going up every year since 2017 based on this rate scale. So for, I pulled this down off of the Department of Industrial Relations website. It's their graphic, which is why 2021 is still highlighted because we're still in 2021. But you can see below that yellow line, we see an increase in 2022. So it will be $15 an hour for employers with 26 or more employees and $14 an hour for those with 25 employees or less. I always just give this caution, which is that if you are on the cusp, make sure you take a look at the requirements under the minimum wage law as to how you count employees. There are some temporary employees that might be included on your employee count that you might not be aware of. So if you're close to that cusp and you want to play it safe, definitely check out and make sure you're counting everyone that should be included. You wouldn't want to inadvertently pay $1 less per hour and be off by one employee. It's way too much liability for such a small thing that could be caught. I want to go back to this slide. When minimum wage increases, it triggers a trickle-down effect into other laws. For example, your exempt employee salary basis test is adjusted up. So the minimum wage has to be doubled, and that's the threshold for your salary basis employees. So they'll receive a raise. Anyone else that has a salary basis test as part of their exemption would also, for example, commission sales employees, that would also need to be increased. So you'll want to double check that all of those folks are receiving the proper minimum wage or minimum salary. Agricultural workers have been experiencing a phase-in of overtime over the last few years. So this law was passed in 2016 and the phase-in started in 2019. So now coming up onto 2022, agriculture employees are entitled to overtime, meaning time and a half, for all hours worked over 8 hours in a day or 40 hours in a week. So this brings them in line with the majority of other employees in the state, not household employees. They have a slightly different minimum wage requirement. Overtime requirement, but you do want to be careful of this if you are employing agricultural workers. And then double time this year, beginning January 1st, 2022, applies for any agricultural workers that are working more than 12 hours in a day. Okay. I just thought this was interesting. There was a report that came out this year about PAGA. For those of you who have experienced it, I'm sorry. It's quite a burden on employers and the legal system in general. So it's the Private Attorney General Act, and it allows one employee to bring claims on behalf of other aggrieved employees in a company or a business. And so this I just thought was very interesting. The value of the cases pending before the Labor and Workforce Development Agency versus the value of the cases filed in court by attorneys is almost double. And you can see that the average penalty paid to the state is significantly higher for those that are brought by the agency versus those that are brought in court under the PAGA. Also, the average amount that the employee receives is significantly lower when these cases are brought under the PAGA, and they take significantly longer to resolve. So employer groups have for a long time challenged that the PAGA did not actually benefit employees. It just harmed employers, benefited plaintiffs' attorneys. Everyone lands different places on that policy discussion. But this data does seem to show that the PAGA claims being filed in court by attorneys are not actually benefiting employees to the same extent that those cases do when brought by the LWDA. And this continues to be an area of high liability for employers because those penalties can stack up, and they are per pay period per employee. So even a very small amount of unpaid wage, for example, just a few minutes of off the clock time can give rise to PAGA penalties that then amount to quite a bit of liability depending on how many employees you have. So this is one of the things that does drive up the risk and the expense of our wage and hour claims. And that's one of the reasons it's such a highly litigated area right now. Okay, enough of my policy discussion. We'll go back into changes to the law. There are increasing penalties related to wage and hour violations. This is a trend we've seen and it continues. There's now a section in the penal code that makes it an intentional the intentional theft of wages punishable as grand theft. That also covers independent contractors. So the penalties for misclassifying your independent contractors are increasing, and there's more risk to individual employers. The Labor Commissioner can now place a lien on real property to recover penalties for violations of the Labor Code, so additional ways to enforce and collect. And as we've seen before, and that has been the case for a few years, there's personal liability for owners, directors, officers, and managing agents who have personal involvement in violating a labor code statute or who cause such violations. And we did have a case this year that clarified this a bit. There was an owner of a company who had very minimal involvement in the operation of the business and no direct oversight or involvement in payment of wages. And she was able to be dismissed from the case because of that limited involvement. But this continues to be an area that is difficult for individual owners or managers who do have a role and who may be named individually as a defendant in a case. Moving on to meal and rest periods, this is an area that was pretty active this year, both in the cases that we handled and in the appellate courts. This is just your standard meal and rest period chart that I just wanted to include as a refresher for you. This has not changed. It has remained the same for several years, but how it's being interpreted has changed. The court held that meal periods cannot be rounded. So rounding is still permissible in California. You can round up to 15 minutes for punching in and punching out at the end of a day, as long as that goes to the benefit of the employee and not to the detriment of the employee. It can either be neutral or it can benefit the employee. That depends on your workforce and if they're always punching in early or always punching in late. So you do have to conduct an assessment of whether or not your meal periods are fair. Your rounding is fair to the employee, but meal periods cannot be rounded. So they have to be the full 30 minutes. So for example, an employee punches out for lunch at 11:02, and that is rounded to 11 a.m. And then they punch back in at 11:25, and that's rounded up to 11:30. That employee did not receive a compliant meal period because the meal period was less than 30 minutes in actuality. So that would be a non-compliant meal period that would give rise to a potential violation. Also, this affects whether the meal period is taken timely. So the meal period must start before the end of the 5th hour of work. If the employee starts if that cutoff time is 12 o'clock, for example, and they start at 12:02 and the system rounds them to 12, that is not a compliant meal period because it was started late. I never recommend that meal periods start on the last minute possible. It's a good idea to give a buffer. So to require your employees to start their meal period by the end of the 4th hour of work, or a 30-minute buffer, whatever it is, you need to be telling your employees to start that before the actual minute it's required, just to give yourself a buffer. Employees have to take a full 30-minute meal period. That's what we're talking about. And then the courts, unfortunately, have been placing higher and higher burdens on the employers. So if your time records, when pulled out of your system, show non-compliant meal periods, that creates a rebuttable presumption that there's a violation. And so this is what really leads to large class actions once data is pulled for all employees. So you end up with one employee who goes to a lawyer and says, and they assess their time records and they say, oh, you have some short meal periods that may potentially give rise to a class action as to all meal periods across your workforce. So it's definitely, I'm going to go through some practical steps you can take here on this next slide to prevent this type of liability. Not prevent maybe, but reduce. So first, you want to ensure that your policy is compliant. A non-compliant policy will give rise to a potential class action. So you want to make sure that your handbook section accurately reflects the current status of meal period law. I actually find more commonly than I would have expected non-compliant meal and rest period policies in handbooks or non-compliant overtime policies. So a good first point of defense is to have a policy that's compliant that you can point to. Also, you want to have written meal period agreements. So meal periods can be waived, if we go back to that slide, by mutual consent if an employee works less than 3.5 hours or less than 6 hours, or it's not required before 3.5, and it can be waived if it's less than 6. And then a second meal period can also be waived, and that has to be in writing. But what we recommend is that you get any waivers in writing, because in almost all cases, by the time we get to litigation, the employee says, no, I did not intend to waive my meal period, even though while they were working, most employees do want to get home earlier rather than stop and take a meal break. But getting that in writing is a great way to prove that the employee actually did agree to waive. Document your training of your employees. So having a complaint handbook section is a great way to start, but you want to show that you actually do encourage and allow your employees to take those breaks. So it's not just on paper, it's actually in practice. And so if you have weekly or monthly staff meetings or safety trainings, it's something to add to your agenda. Are we taking our meal periods? Let's remember when they have to be taken. Let's remember how long they have to be. So that's a great piece of evidence that you can use, that you were providing the legally required meal and rest breaks. Same goes for off the clock time. Documenting that in your training materials does create evidence that you intended to pay your employees for the time they were working. Compensating your employees for non-compliant meal periods that were due to the press of business is another way to show that your policy is being enforced in a compliant way. If we have a workforce of 500 employees and you've never paid a single meal period premium, especially if your business involves emergencies, that is going to potentially allow class action to proceed on the basis that meal period premiums were not being paid, because inevitably there are reasons that an employee would be prevented from taking a timely meal break if there was an emergency that they had to respond to. And so they would be entitled to that 1 hour premium. And if you can show that you're paying those occasionally when press of business does require it, it goes a long way to creating good defense evidence. Also, have your employees or their supervisors or both document that if they didn't take a meal period timely or their meal period was short, that was due to their own voluntary choice rather than being due to the press of business or some emergency. So for example, you could have the employee fill out a form. You could have a lot of timekeeping systems flag short meal periods or late meal periods, and then you can get that documentation about why it was that that employee didn't take that meal period. For example, they came back and just happened to check in a minute early. No one required them to. They didn't want to stand there and wait a minute to clock back in. That kind of documentation is also helpful and shows that this isn't a company-wide policy or practice, it's really individualized. That can again prevent a class action and create good evidence in an individual claim as well. Also, prevention goes a long way. It's much better to identify trends in your workforce, divisions that are always clocking out late, classifications of employees that are always coming back early before there's a claim. So notice if there's a trend. Notice if you have a supervisor that is routinely having people leave late for their meal periods, and address that proactively rather than before there's a claim. And a lot of this does come down to your frontline supervisors. Your HR professionals know this. Your upper line managers often also know this. But it's that supervisor on the ground that's holding people over, or that's not giving that buffer period for the end of the meal period, or that's not noticing that employee A is just consistently taking short meal periods. And they can really, if you train them, catch a lot and reduce your liability significantly. I have a question here. Is there a centralized location for the recordings of past webinars? Any webinars that I have provided for free are available on the Kroloff website. There's a section for videos, and you can go back and look through those. I'm thinking of taking some down that are old because they're out of date now. I also do have a set of helpful short videos, 3 minutes in length, on various topics that are common questions. I direct my clients to those. I have one on commissions, I think, one on meal breaks, things like that. So you can check on our video site. Also, here's my next question. What is your opinion on companies having links to policies in the handbook versus the policy being written in the handbook? This is going to, I'm not quite sure about this. You can have your handbooks online. They need to be available and accessible to the employees, and you need to have some way of documenting that the employee received it. But if there's a table of contents and then they click into each policy, because that's how it's easily presented on your electronic system, I don't see any problem with that. If you're handing out a hard copy, it should be complete. The case law does, I think, trend toward wanting the employee to have full and complete information when provided in hard copy, and those links should be easy to get to. So some kind of an index or a table of contents that they can click on is fine, but there shouldn't be any obstacle to them getting that information easily and quickly. Oh, webinars you paid for that you lost the links to. Go ahead and email me, because I should have those saved on my system and I could send them to you again. But they might not have stayed online. I had some that were on demand, for example, and those expire. So, but I think I have most of them saved. So if you email me, I can get that to you. The link to our website is kroloff.com. That should take you to our main website, and there's a video link on the top. Okay, moving on. Here we go. Regular rate of pay. This has become a big topic in the last few years, because the courts have changed the way that, or the types of pay that regular rate of pay applies to, and it's been made retroactive. So this is something to pay attention to and something to check. A good item for you to look into this year before we go into the new year. So the regular rate of pay as it currently stands has to be paid for overtime premiums. Sick leave, for most non-exempt employees, there's a 90-day look back that you can use, and there's a separate way of calculating it for your exempt employees. But sick leave typically now has to be paid the regular rate of pay. Reporting time pay needs to be paid at the regular rate of pay. Meal period premiums, we had a case this year, need to be paid at the regular rate of pay, and rest breaks for piece rate employees. So what this requires you to do is to make sure that whatever the formulas are in your payroll system, that they aren't just paying the flat hourly rate times 1.5 if your employee receives multiple rates of pay. So the types of pay that have to be included in the regular rate of pay are the hourly pay, of course. If I earn $14 an hour, that goes into the equation. But what if I also earn a shift differential because I work nights? That has to be included. So if someone works overtime overtime on a day in which, or in a pay period in which they received a $40 payment for a shift differential for working a night shift, that has to be factored in to the rate of pay they earn for overtime, and it has to be increased slightly to reflect that. Any salary an employee receives, if they receive, for example, salary and hourly pay, piece rates that they receive, commissions they receive, and any non-discretionary bonuses that are based on performance, sales, any kind of calculated metric that's not discretionary. You don't have to include gifts like a Christmas gift that you may give out, discretionary bonuses, expense reimbursements, as long as they're legitimate. We had a case on that this year where expense reimbursements were actually not expense reimbursements. They were being paid only to certain types of employees for hours worked. So you want to make sure they're clear expense reimbursements. Benefit plan contributions, medical, dental, etc., or maybe flexible spending plans, etc. Meal and rest period premiums don't have to be included because that would double up. And then pay for, I've got something in front of it. Oh, time off such as vacation, etc. So those are excluded, but any other types of pay for work performed are basically going to be included in the regular rate of pay. So I have a slew of slides coming up. that we don't have time to go through in detail. This could be a whole webinar in and of itself on the regular rate of pay, but I just wanted to include an overview for you. So when you're going through and evaluating your current policies, that you have kind of a template to look at, to issue spot, I should say. This is not comprehensive. It doesn't go through every specific situation that arises, and it doesn't go through intricacies that relate to your workplace, but hopefully this should give you an idea of, oh, my pay is a little more complicated than I had thought. Maybe I should get a legal review of how my regular rate is being calculated here. So someone that's receiving hourly pay and commission, you would include their straight time and their overtime premium. And this is how you calculate the overtime premium. Total earnings divided by total hours worked times 0.5 times overtime. So if that is confusing to you, or that doesn't comport with what you thought it was, it's probably a good idea to have that checked out. The salary would be the salary plus the overtime premium, and you would calculate the overtime premium by dividing the salary by 40 hours, multiplying by 0.5 and multiplying by the amount of overtime. Flat sum bonus. The employee would get the flat sum bonus, for example, a safety bonus each month if safety scores for the workforce are in a certain range. And then you have to true that up for any overtime that was received in the bonus earning period. All right. Regular rate of pay. That was simple. The hourly pay rate. If they only receive $14 an hour and nothing else, then you're times 1.5. I have some examples here, but we don't have time to go through them today. Salaried workers would be their monthly salary times 12 months divided by 52 weeks divided by 40. Piece rate and commission workers are a little more complicated. You're going to do total hours in the work week, including during overtime hours. That differs from federal law, divided by total hours worked. If they have 2 or more rates, we call it the weighted average. So total earnings divided by total hours worked, including overtime hours, gets you your regular rate. Production bonuses are bonuses earned on sales, for example. When an employee is also earning an hourly pay, we do the production bonus divided by total hours worked in the bonus earning period times 0.5 or times 1 for double time, times the total hours of overtime worked. Flat sum bonuses, you take the regular rate of pay, is the bonus amount divided by non-overtime hours worked in the bonus earning period, multiplied by 1.5 for each overtime hour worked. This is, yes, different than the production bonus. Why? The court has a complicated reason for explaining why it's different. All we really need to know is that it is different. So you need to be able to identify what type of bonus are you paying and is it being calculated correctly. So as you can see, it's really important to make sure that your payroll software is calculating these correctly, because this is something that really commonly trips up employers. And it has changed over the years. So if you haven't checked your formulas in 5 to 10 years, it's time to check them. All right. Oh, okay. So that's it on my regular rate of pay. It's more of a word of caution and just a really great area to double check if you haven't done so recently. And because the types of pay that require the regular rate of pay calculation have changed, you want to make sure that's being done too. You want to look at those different types of pay. Is my meal period premium being properly calculated, for example? Okay, so there were some industry-specific changes to wage and hour law. Food delivery and facility personnel have to keep their tips. So that changed. There were some food delivery companies that were keeping a percentage of tips, and the law has clarified that. So if you fall into that category, make sure you know the ins and outs of that new requirement. Warehouse distribution centers now have to disclose quotas to their non-exempt employees, and they have to ensure that their quotas are reasonable and allow the employees to take their required breaks. Garment manufacturers are prevented from paying piece rates Sub-minimum wage for disabled workers is being phased out. Unionized janitorial workers can't bring PAGA claims depending on the language of their CBA. So these are all things, if your industry falls in, to learn more about and make sure that you're complying with. I don't have time to go through them all in detail, but I just wanted to allow those of you in these industries to issue spot and be able to go back and double check these things. And also, if your wage rates are changing, either because of a change in the law like this, or for any other reason, you do have to provide that in writing to your employees. So make sure that you're complying with the wage, what is it, the Wage Theft Prevention Act notice requirement in the labor code. Oh, there we go. Okay, so that is the end of my wage and hour section. I'm going to go into harassment and discrimination, and then we're going to move on to safety, but I have some questions. Oh, I did getting follow-up questions on whether the policy is available by hyperlink, but not in the actual handbook. I mean, this kind of what policies you include in your handbook versus provide as a separate policy is a bit of a business decision. There are some policies like pregnancy disability leave or harassment that the law says have to be in your employee handbook. So those have to be in your employee handbook, but you could have standalone policies. For example, I didn't recommend that my employers incorporate COVID policies into their employee handbook in the last 2 years because they were changing so rapidly and no one wanted to reprint and redistribute their entire handbook. And it gets kind of messy to be issuing handbook addendums and keeping track of them. So we were issuing, for most of my clients, standalone COVID policies. And vaccination policies, for example, because they change rapidly. So which policies you include in your handbook and which you issue separately or provide hyperlinks to outside of the handbook is a decision that you should be making with your counsel to make sure that it isn't required to be included in your handbook. Can handbooks be emailed to employees? Yes, you can provide electronic copies of your handbooks. And they can be provided by hyperlink. They can be provided online through your online data system. But you do want a way to verify that the employee received it. So in a lot of systems that are all online, for example, for paperless employers, they click an acknowledgement that they received and were able to read the handbook. So you just want some way to document that, which is the concern with just emailing. Perhaps you could have them sign the acknowledgement that they received it by email, but you do want to make sure you have documentation that was received. Okay, any other questions on the wage and hour section before I move ahead? No. Okay, very good. Moving into harassment and discrimination. I know we're kind of flying through the material, but this is more of a issue spotting webinar on what to be looking for rather than specific training on any particular area. Last year, we had 2 years ago, actually, a new law requiring and expanding the amount of harassment training that your employees receive. Supervisors have to receive 2 hours of training every 2 years, and all employees have to receive 1 hour of training every 2 years, and then training has to be provided to anyone that newly falls into one of those categories in 6 months. So this year, 2022, is coming up on the period in which a lot of employers had trained in 2019, and so we're coming up on that 2 years. So you want to make sure that your records are up to date, that you've checked, and that you redo training for anyone that needs it. We still see harassment cases. I know wage and hour is really driving a lot of the litigation right now, but we still see harassment cases. So you want to be careful to keep those policies in place that you have and to enforce them well. So one, your employee handbook should have a valid harassment policy. That has changed in the last 10 years. So if your employee handbook not been updated in a while, you're going to want to make sure that your current policy is valid. I also recommend that your actual policy be distributed with your harassment training. So you can do these online trainings. There's a free one through the DFEH. I understand that some of the technical issues have been worked out on that. You can purchase seats through various online providers. I offer these trainings to large groups. If you want to get together with a few employers, I just charge for the time, so I don't care how many people attend, but you want to give them a copy of your policy. So you want to make sure that your policy is actually current and valid when you hand that out. Ensure that you have quality training conducted. The problem with online training sometimes is that employees aren't really paying attention. The DFEH program, legally compliant, but not super interesting. Live, if you're having concerns about harassment in your workplace, having a live presentation conducted by a consultant, you have to have someone that fits within the requirements of the code. You can't just have an untrained employee provide the training, but someone who meets the requirements can provide the training on site. That's really the best way to go if you're having a lot of concerns. Train your supervisors. Again, that's that frontline supervisor. If they see something, they should report it up the chain, because they really have a lot of the ability to reduce your risk, catch something early, deal with it promptly, conduct investigations that are prompt if you get claims of harassment. And then be aware, we had a case this year about a customer in a bank that was harassing an employee. A hostile work environment can be created by non-employees, by volunteers, by customers. You have an obligation to protect your employees, regardless of the source of that harassment. For those of you who employ nurses, there was a change in the law for nurses. They now have to receive implicit bias training as part of their nursing program. They have to complete implicit bias training within the first 2 years of licensure, and hospitals who conduct graduate training programs have to provide training. Okay, so that's it on discrimination and harassment. Except for, we already went over settlement agreements on harassment and discrimination. Do we have any other questions on that area of the law? No. Okay, great. We're moving on to leaves of absence. The California Family Rights Act was expanded significantly in 2021. Those changes all remain in place, and there has been a slight expansion to parent-in-law. So that you want to make sure your handbook has that if it doesn't already. This provides 12 weeks of leave for an employee's serious health condition or the serious health condition of a family member. For those of you that I did your handbook last year, I also provided some templates to use to implement this. If you don't know how to implement it, that could be a whole nother presentation, but you want to make sure that you are implementing it and that you are counting the leave correctly and giving notice of this leave. There were quite a few cases this year under the federal law about whether failure to provide notice was interference. Those cases came out by and large in favor of the employers, but it is a requirement that you provide notice of the right to take CFRA leave. Eligible employees have to have been employed for at least 12 months. They have to have worked 1,250 hours, and pregnancy, different from the federal law, is not included. Pregnancy and pregnancy-related health conditions, but employees can then take baby bonding under CFRA, and how the hours are counted for that is slightly different. So here's a little graphic about how this works. So for example, pregnancy is not covered under the CFRA. That's a different law, the Pregnancy Disability Leave Law. So your employee could take 2 weeks of CFRA for knee surgery, then they could take 8 weeks for pregnancy disability leave. Then they could take another 10 weeks for baby bonding. So we get to a total of 12 because they use 2 for a knee and 10 for baby bonding. And then we have to remember that pregnancy disability leave covers conditions that are extended, like postpartum depression. Also, we have an obligation to accommodate a disability under the Americans with Disabilities Act and the Fair Employment and Housing Act. Those don't have particular outer limits. That's an undue burden analysis that you need to engage in. You need to engage in the interactive process with the employee to determine what kind of leave or other accommodation is available. So once we get to the end of the 12 weeks or the end of the 8 weeks plus the 12 weeks, you still have to accommodate a condition that constitutes a disability. Okay, I thought I had a question, but there isn't one. Okay, so moving on. There is a new provision. Well, it was part of their law originally, a pilot program, but I just thought I'd include it so that you're aware of it. The law changed slightly this year. When an employee requests an immediate right to sue notice from the DFEH alleging a violation of CFRA, the DFEH has to provide notice of the pilot program and the mediation requirements. So there's a mediation option here prior to filing a civil action. So the intricacies of this, we don't have time to go into today, but I wanted to make you aware of it. And you might be seeing it now in the new DFEH notices you're going to be receiving. Okay, that's it on leave updates for this year. It's a high area of liability. The laws overlap and interact, and there's a lot of them. You want to make sure that your handbook is compliant. You should have a policy that addresses sick leave, a policy that addresses pregnancy leave, a policy that addresses disability leave, a policy that addresses CFRA, and if you have more than 50 employees, FMLA. There is also, for those of you with 50 or more, a few other federal leave laws. And there's other laws in California that at least I like to reference in the handbook, but not go into in detail, like bone marrow leave, for example. So that's one area in which your handbook is important to be compliant because it provides proper notice of those leaves. So the handbooks that I prepare include those categories. And the FMLA and CFRA policies began to diverge last year because CFRA was modified pretty heavily. So if you didn't update your handbook last year with regard to CFRA and FMLA, I would definitely recommend making sure that you bring that up current this year. Okay, moving on to independent contractors. As we all know, we're just going to go through this briefly. The ABC test applies in California under AB 5. The worker has to be free from the control and direction of the hiring entity. They have to perform work that is outside the usual course of the hiring entity's business, and they have to be engaged in independently established trade, occupation, or business. So B and C are usually the hardest to meet now. Those were the kind of areas of biggest change by this. I still get a lot of questions on what are the exceptions. I don't think there were new exceptions passed this year, but some of the existing ones were extended. So we don't have time to go through all of these, but there are specific occupations. I get a lot of questions. I want this person to be an independent contractor. Do they fit within one of the exceptions? And an exception doesn't mean they're automatically an independent contractor. It means that they have to meet the Borrello factors. It's a 10-factor balancing test that goes through control, equipment, different factors. So physicians, surgeons, dentists, podiatrists, psychologists, and veterinarians, for example, can be independent contractors if they meet the Borrello test, not the ABC test. So here's the list of specified occupations that are exempt from the ABC test and that the Borrello test applies instead. There are professional service providers that are specifically listed. Here we have the whole long list. That bottom one for manicurists, cosmetologists, there was a sunset period on that that has been extended. Professional foresters, the list is long and varied. And these individuals, there's a 6-part test that they have to meet 6 criteria in order to fit in the exemption. So not only do they have to be a travel agent, but they have to meet 6 additional criteria. Business to business contract relationships. So say I run a sole proprietorship, I'm a bookkeeper, and I serve multiple businesses in town. I have to also meet the requirements that are set forth here. So if someone's providing a business service, they fall within this exemption, but there's quite a few criteria. Additional exemptions, it's really a hodgepodge. Single engagement events, DJs, caterers, or musicians at like a wedding, for example, are independent contractors if they meet the Borello factors, because they fall within an exemption for the ABC test. Construction subcontractors have their own set of criteria to be exempt. Real estate licensees are a hybrid because the unemployment and workers' compensation codes have different requirements for these folks. So if you have real estate licensees and you aren't familiar with these tests, maybe this is something you would want to look into this year when you're doing your assessment. Music industry has its own requirements. Referral agencies, that's something like care.com, for example, or other websites where someone can sign up to be listed and referred out, but they aren't employed by the referral agency. App-based rideshare and delivery drivers have their own exemptions. And then there's a kind of mishmash here on the bottom: data aggregators, commercial fishermen. That bottom one is AAA's tow trucks, licensed repo agencies. So if you have a question about whether your independent contractor fits any of these exemptions, that's something you want to look at and maybe get an opinion on. I do recommend periodically pulling your 1099s just to see who you are paying and making sure that you have written contracts so that you meet all of the criteria for the exemption, because misclassified workers do create a significant amount of liability. And we see, like we talked about earlier in today's presentation, a lot of additional enforcement, additional penal code violations, etc. So this is something you want to make sure you're doing correctly. Okay, that's the end of my independent contractor section. Do we have any additional questions on that? No. Okay, very good. We're going to move along. I have only a couple more minutes. So workplace safety and COVID-19. There were some legislative updates. If you've watched my last COVID-19 presentation, they were included in that. If you want to see that in more detail, it's up on my website. Notice obligations were updated. So previously you had to provide notice of an exposure to employees who may have been exposed, which were those that had a close contact with the individual with COVID. Now notice has to be provided to all employees who are on the premises at the same work site as the qualifying individual within the infectious period. So it's more broad. So you're going to be providing more notices at this point under this new law. You have to give notice of COVID-19 outbreaks to public health departments within 48 hours or 1 business day, whichever is later. An outbreak is 3 or more employees. The notice must include, this should be flopped with that bullet point above. The notice to those employees who are on the premises has to be provided and include related benefits. So example, workers' comp, maybe disability, disinfection protocols you're going to follow, safety information you're following for COVID safety, and this is actually anti-harassment and retaliation policies. There are new recall rights, maybe not new, but they remain in effect through December 31st of 2014. They came into effect earlier this year. Employees who were employed by a covered employer for 6 months or longer during the 12 months before January 1st, 2020, are entitled to notice of job openings and preference potentially in rehiring or in hiring if they were laid off due to a COVID-related reason. There's specific requirements for the notice that has to be provided to the employee. So if this applies to you, you're going to want to make sure that you're complying with this. It's SB 93, and these are the types of businesses that are covered: hotels, private clubs, event centers, airport hospitality operations, airport service provider, and building services. So if you fall within any of those categories and you laid people off due to COVID, this is something you're going to want to take a look at. Cal OSHA is expanding its enforcement, and the legislature passed some new laws that give it more enforcement this year. And really, this raises the issue of businesses being sure to comply with Cal OSHA requirements. This was kind of on the back burner for a lot of businesses that weren't high-risk businesses. And it's really brought to the forefront the importance of having an injury and illness prevention plan in place that's required for all employers, for making sure it's updated, for making sure you have a COVID supplement or that you've incorporated COVID into it, and that you're training on that. Just because the state has reopened and we're back to business doesn't mean that you can ignore COVID. It's a recognized safety hazard, and you have to make sure that you keep your employees safe from it. So you need to follow the Cal OSHA temporary standards, but then you also need to make sure that you have a good safety plan in place. Violations have increased. So there's two new categories: an enterprise-wide violation, which is a rebuttable presumption that a violation at one of your work sites is enterprise-wide, gives rise to greater penalties and kind of more expansive enforcement. And then also an egregious violation, which is a willful violation of a health standard. So there's 7 factors for deciding whether something's egregious. But again, this is just raising the importance of prevention in workplace safety and the increased enforcement. COVID has really brought that to the forefront. There was always that liability out there, but it's increased. And also Cal OSHA can now seek injunctions to protect employees and issue subpoenas for information. So their enforcement has been increased. This is the ETS standard. It's still the current one in place as of June 17th. So if you watched previous webinars, that's still applicable here. We're waiting for a new standard to be released relating to the 100 employee vaccination requirement. That's currently pending in the courts and has been stayed, but that's something to keep up on and note if it changes. I don't have time to go through mega events. This is a vaccination requirement for 1,000 people indoors or 10,000 people outdoors, vaccination or testing. And I have those slides, you could take a look at them. Masks are only required in limited situations at this point in time. They're listed here. If your industry falls in one of these, you're going to want to make sure masks are worn. These are recommended mask requirements and requirements for unvaccinated persons. Cal OSHA has mask rules. They're here, and this is the same as my prior COVID presentation. If you want to take a look at that, it's up on our website. These are the current vaccine mandates that are in place. Down there, number 8 is the one that has been stayed. So there are a lot of industries in which vaccine mandates have come out in the last 6 months. There are exceptions for religious beliefs and qualified medical reasons. You need documentation of that from the employee. And then those who fall within an exemption have to either be tested or have to be tested and must wear masks. So this is something to be aware of if you fall under one of the mandates. This is a slide that addresses religious beliefs. They're pretty expansive. If you have a religious objection to vaccines and you have a vaccine mandate in your workplace, either imposed voluntarily by you or by some kind of state requirement, that might be something you want to consult with your attorney on, because they're a little bit difficult to parse out, and every business has a different approach to how strict they want to be in investigating whether a religious belief is sincerely held. This is the stayed temporary standard. I have kept the slide in because we're still waiting to see what's going to happen with that. For those of you who have kids or who work in the schools, once the vaccines are approved with full approval for young people, they're going to start being required along with, the other vaccines that schools require for children to attend public school. Okay, the last thing is I've been getting a lot of questions on the COVID-19 leaves. So these have expired for the most part, the sick leave for COVID. So what we do at this point in time is we apply our existing leave laws, our pre-COVID leave laws, sick leave, workers' comp leave, Cfra leave, because COVID is a serious health condition if you have a severe case of it, the Fmla, disability accommodations. Long COVID might be a disability in some situations, or someone who has a disability might be at higher risk for COVID and need a leave of absence, or might have a more severe case of COVID. So you want to be aware of that. There's school and childcare leave, which applies when a school is closed due to an outbreak, or a parent is called to pick up a kid due to an outbreak. And then those are the protected types of leave. There's also some wage replacement available. If an employee is exposed at the work site, so it's work related, they have to be paid for the time they're excluded. They can be paid through state disability benefits or through sick leave, but if those run out and they're still excluded, there might be an obligation for the employer to pay. Employers also have to pay for time where employees are required to get tested or required to be vaccinated. That's considered to be work time. And workers' comp benefits, if exposed at work, could provide some compensation for an employee who's out and significantly ill. And that's it. I reached the end, probably late. Yeah, 7 minutes over. Sorry, I knew it was going to be a lot of material. I should have talked faster at the beginning. But I'll stay and answer any questions you might have about any of that material. There's my email right there. If you would like to request a copy of the slides, I'm happy to provide it. This will be up on our website either Monday or Tuesday of next week at kroloff.com, and you can catch my other videos there as well. If you have any questions, go ahead and let me know. Oh, I see them coming into the Q&A. I have to scroll down. Okay. I have a question about where's a source of laws if you don't have counsel. The California Chamber of Commerce is a good resource. They publish information and white papers if you're a member. They have good materials available. I recommend that small employers look at their materials quite often. So that's a good source of information, I think. Attending these types of webinars, I'm not the only lawyer that puts them on. So you can look at my webinars, or you can check out others that are available. I have a question about leaves. Employee takes 12 weeks FMLA for pregnancy and then baby bonding. Do they have another 12 weeks for CFRA with 8 weeks paid under paid family leave? So FMLA runs consecutively with CFRA if it's not for pregnancy. So yes, they do get the extra baby bonding time if they're FMLA. So FMLA would run concurrently with pregnancy disability leave, because if someone's placed out on disability by their employer, that leave is starting to run. So FMLA is going to run down with PDL, and then they still have the CFRA baby bonding. So yes, they do get extra in California versus your employees that are outside of California. And paid family leave is not job protection, but it is a pay. And so baby bonding is paid under the paid family leave law in California. It's implemented through the Employment Development Department, just like disability leave. And actually, if an employee takes pregnancy disability, they're going to get a notice automatically from the EDD that they're entitled to receive pay under paid family leave. So if they're working for an employer with 5 or more employees, and they meet the qualifications for CFRA because they worked there longer than a year, et cetera, they're probably going to request that leave from you. If they don't qualify for leave for baby bonding because they didn't work for you long enough before the leave of absence, for example, that state leave law exists. I mean, the state wage reimbursement exists, but you don't necessarily have to hold their job. Now, terminating a pregnant employee or an employee that just gave birth is a high risk termination. So you're going to want to consult with someone on that. But that's the way those laws overlap. Okay, I think I've answered all of the questions today. And if I didn't answer your question, ask it again. Feel free to shoot me an email about something that I went over today. And I'm happy to answer follow-up questions on the presentation by email. I can't answer legal questions relating to your specific employees by email because we have to have an attorney-client relationship for that, and I need to know all of the facts to give you good advice. But I'm happy to answer, the type of questions I would answer in the webinar about basics. If you want to shoot me an email if something comes up. Good luck to all of you as you continue to try and comply with California employment law and reduce your risk and provide good work environments for your employees. So thank you for attending with me today. And I hope to see you all at my next presentation, and happy holidays and happy new year.